Now, Mr. Sprains, Mr. Rubin, unfortunately, Lord Justice Phillips is extremely unwell today and can't sit. We think, Lord Justice Popplewell and I think that it would be sensible to continue with the case rather than adjourn it. But obviously we will listen to anything you have to say. I think we're empowered to sit with two judges, but obviously it's very disappointing for all concerned. But do you have anything you'd like to say about that?
Certainly from our perspective, my lord, we agree with your conclusion, you're empowered, and we agree with the conclusion that you should proceed.
Mr. Rubin?
My lord, yes, I agree with that.
Okay. Well, we will do just that then. We will continue with Mrs. Savithy. Miss.
My lord. Overnight, the parties have agreed an updated chronology.
So, what are you handing up?
An updated chronology.
Okay, we got that. We got it electronically.
Would you like it?
In due course. Don't take any time about it. It'll come up in due course. Go on with your submissions.
Yes. Thank you, my lord. I will be very short this morning. I think yesterday I was showing you a few Hansard references which reflect the legislative intention was to limit the application of Section 5 to the penal element. Can I finish off those Hansard references, if I may? That's at tab 23. The authorities bundle.
Sorry, somebody has just unplugged me in some respects, so just give me a second. They seem to have a marvellous wish to unplug my screens.
Is that not? Looks like it might be on.
Oh, there we go.
Yeah.
Sorry, Miss Surathi. Please continue.
Thank you, my lord. It's at page 700.
Sorry, say that again.
Page 700 of the joint authority.
Of the
authorities bundle.
page 7. Yes.
And this is the remarks of Mr. John Smith, and it's the third paragraph down where he says, Clause 5 restricts the enforcement of overseas judgments. It may do no more than declare what the existing law is and what the courts might apply, and puts it into statute form. That is a matter that could be examined more closely in the committee. It does not raise a tremendously important point of principle. The next reference
Sorry,
is it.
excuse me.
I'm not getting the rolling transcript, but it's not worth holding up the proceedings.
No, I haven't got them anyway, so there we are.
The next reference is at page 709. This is to the observations of Mr. Charles Fletcher Cook MP, and it's at the beginning. I entirely support Clause 5. It is in conformity with the principles of private international law. And then the sixth paragraph down, we cannot say that multiple damages are of themselves inherently wicked because they appear in many systems of law in various forms. They are certainly penal. It is a rule of international law that no country's courts will be allowed to be used in other countries for the benefit of recovering penalties that are enforced by other countries.
I mean, how does any of this help us, really? I mean, what are we getting out of it? Tell me what the submission is that we should get out of these contributions to Hansard.
Well, my lord, the submission is that what Parliament was concerned with is the penal element of a multiple damages award, which is restricted to 2/3 of that award. And at the bottom of the next paragraph, which is 3 paragraphs down, it says, to my mind, 2/3 of the triple damages is surely a penalty.
Sorry, where are you?
3 paragraphs from the bottom of that page. It's the last sentence.
Yeah.
I got you, thank you.
And on page 718 for completeness, Mr Tebbit, who's the Undersecretary supporting the bill.
There's really some characters from the past in this,
Indeed.
this transcript, aren't there? And I rather like the reference to the dreary case called Huntingdon and Attrill.
Which he doesn't appear to agree with, I think.
Well, we can agree with that. Yes. Okay, keep going. I'm sorry.
Page 718.
Tebbit refers to as a book that he couldn't go to bed without.
They're livelier in those days.
Yes.
Page 718. And he's referring here to those observations of Mr Fletcher Cook in the 4th paragraph down.
I think they had more fun in the House of Commons in those days.
That might be right, judging from this.
Yeah.
4th paragraph down. The second 2 sentences, he agreed that the extra element of the damages is penal. He explained clearly that our courts do not enforce and have never enforced foreign public penal laws. That is the essence of clause 5. So our submission on the basis of these materials is that what Parliament was intending to prohibit is the extra 2
Yeah.
amount.
Yeah.
And that purpose has also been recognised by the courts. If I may just give you one reference without turning it up, it's the British Airways case by Mr Justice Nelson, where Section 5 was described as based in essence on the principle that courts here will not enforce penal laws of other countries, and that's page 163D.
Sorry, the British Airways case,
Uh,
Mr Justice Parker.
No, Nelson.
Nelson.
Well,
Page.
Parker, sorry, that's right.
but I thought it was
One-
Mr Justice Parker who was the judge at first instance in the
Yes,
British Airways
sorry,
case.
that's my error. 163D. So section...
Sorry, can we just look at that? I thought Mr Justice Parker had said in terms, but it bars the whole of it. This is at tab 2, is that right?
Yes.
Which is bundle. Page
33.
It's 31 where that section, that is
Yes.
at 31, goes to the
Yes.
whole of it.
Yes, that is. The sentence on which I was relying is at page 33. D. It was only, I conclude therefore that whilst section 5 is based on essence, on the principle that the courts here will not enforce the penal laws of other countries.
Yes.
And what we say is penal here, looking at the Hansard materials, is referring only to the 2/3 extra element.
But Mr Justice Parker thought it referred to the whole of it. See page
Yes.
161E.
Yes. He wasn't obviously considering this question. They are observations in the construction of section 5. Section 5, we say, is properly characterised as a statutory exception to the broad principle of recognition and enforcement at common law. And that's Lord Justice Potter and Lewis. And we say that in interpreting that statutory exception, regard needs to be had to the presumption against the imposition of a penalty, absent clear language. So insofar as Section 5 precludes a judgment creditor from recovering the compensatory elements of a judgment that would otherwise be recoverable at common law, that would in itself involve a penalty. And that was the reasoning of Mr Justice Mann in Lucasfilm at paragraph 230.
would that be your submission if the judgment creditor had already recovered and enforced the non-compensatory element abroad?
Yes.
So
If
the court would be bound to give effect to all elements of the treble damages, because it would have to treat what was being enforced in this jurisdiction as the compensatory element.
yes,
Why? Suppose that in the United States
yes,
they happen to have found assets
yes,
that were worth 2/3 of the judgment.
yes.
On what basis would you say that if they found assets worth 1/3 of the judgment in this jurisdiction, the attempt to enforce it here would be the compensatory element? Why would it be the compensatory element?
Well, the question before the court would be the enforcement of the compensatory element.
Why?
Section 6 of the PTIA provides a remedy for the judgment debtor if they're based in the UK to recover the punitive element.
Well, if there are assets
they
against
can.
which they can, but
Yes.
assume the position is that the judgment creditor in the we've got a $300 award,
Yes,
which is $100 compensation. In the United States, the judgment creditor has found $200 worth of assets
yes,
and has enforced against them.
yes,
And the judgment creditor finds another $100 of assets in this country
yes,
and wants to enforce against those in this country. You say, as I understand it, that $100 is the compensatory element
yes,
and can do so. And the fact that under Section 6, if it could find assets to enforce against by way of clawback, it could
Yes.
claw back
yes,
part of it.
yes. Well, that-
Isn't an answer, is it, to whether the shield of Section 5 is available?
We would say Section 5 is concerned only with enforcing the punitive amount, and that is the effect of the legislation.
But in the example I give you,
Yes.
why would the $100 in England not be part of the punitive amount? Why would you treat it as the compensatory amount? Why wouldn't you treat the compensatory amount as being part of the $200 that's been recovered in the United States?
In your example, my lord, you'd have separate awards of damages, which are referable either to a compensatory sum or a punitive sum. And if you are concerned with enforcing what is recognised to be the compensatory sum, then Section 5 doesn't prohibit you from doing that. But what you have is
in
a
my
remedy
example,
under Section 6.
how do you recognise it? You've got a judgment in the United States for $300.
Yes,
You've just enforced it in relation to a particular chattel which is worth $200.
yes.
How do you identify it?
But I
By
think
way
the
of
answer is
enforcement.
Section 6. The answer is Section 6, that you'd be entitled to enforce a compensatory sum and you'd be entitled to claw back what is the excess.
And if there weren't any assets available in an available jurisdiction from which you could claw back, well, how does that satisfy the purpose of the Section 5 shield?
I think that is what would follow from the statutory language, and that is the consequence of the statute.
Thank you.
May I briefly take you to the reasoning of Mr Justice Mann and Lucasfilm, if we haven't gone to it already, and we may. So it's Authorities tab 10, page 391. And it's paragraph 230.
Yeah, we've looked at this before.
Yes, and the part in which we rely, for the purpose of my submissions on the presumption against penalty, is his observation that would, in my view, smack of a penalty and would require clear words than appear in the statute to justify its imposition. I do not think the wording is sufficiently clear.
My lord, I just raised to say this is essentially re-arguing the points that we had from Mr. Strange
Yes.
yesterday. I've got a note against this paragraph, and Mr. Strange actually read it to you.
So have I. Yes, I mean, I don't want to stop you because obviously, but we were planning on finishing today.
Yes.
We haven't got anywhere close to arguing some of the points in the Calver appeal,
Yes.
and I thought you were dealing with the human rights arguments.
Yes. Well, I'm just about to finish up.
Okay.
And so we'd say the presumption against the imposition of a penalty requires that absent clear indications to the contrary, Section 5 is not to be interpreted as including the purely compensatory element. We also say to conclude that we get to the same result by the operation of the principle of legality, which is the human rights point. It is presumed that Parliament doesn't intend to legislate contrary to fundamental rights or other basic tenets of the common law, and it would not be taken to have done so unless it makes its intention to this effect very clear by express language or necessary implication. One such right is the right to peaceful enjoyment of property, the judgment creditor's common law right to enforce a judgment here, at least so far as that judgment would have been amenable to enforcement at common law is such a right, we'd say. And we say the same is true of a judgment creditor's common law right to enforce a foreign judgment. It is in substance no different from a debt, and it's amenable to the court's processes. Unless I can assist you further, that's all I was raising.
Okay, thank you very much. Where are we going now, Mr.
We're going to close out PTIA so I can start revocation. To close this section out, I just want to summarise what I say are the guidance or the principles to take from Lewis, and then have a look at the Calver judgment. In doing so, it occurred to me yesterday that we were very much focused on the DTSA compensatory aspect. We didn't spend too much time on the interest, the costs and the fees, and how they fit into that language, which I'm going to do.
Good.
So in terms of the principles, I've taken you to the passages from Lewis, but I'll just give you the principles and the paragraph numbers. So the first principle being that this is a statutory exception to the broad principle that we have in this jurisdiction of recognition of foreign judgments, an approach that's been pursued for several centuries by reference to both comity and the doctrine of obligation. Second, that ordinary compensatory damages should be open to enforcement unless plainly precluded. Now, I accept that he said that in the context of the facts before his case, but I say the focus on ordinary compensation should normally be subject to enforcement stands. The next point is this, that per ruling, where the court is asked not to enforce a foreign judgment and is faced with a plea that it's unenforceable, the court should first examine whether and to what extent the judgment falls within the exception to enforceability. And if only part of the judgment falls within the exception, the court should consider whether the unexceptional part can be readily distinguished, separated, and quantified for enforcement. A single judgment is not an impediment if readily identifiable. So that's paragraph 52. And there it was concluded that's a sensible and robust approach to interpretation of section 5. And then, closing out his judgment, composite judgment does not treat the multiple damages element as infecting the rest. And I say that's where the judge fell in error at first instant, because he infected everything else with the multiple judgment. Now, Lord Justice Jacob, we've been through his 3 iterations of the words, and what we say is when you're looking at absurdity, enforcing compensatory aspects that are capable of severance or are readily identifiable, you should do it. Not to do it would amount to a severe injustice. And I say there's no real distinction in terms of a severe injustice between what happened in Lewis with the fraud claim and what would happen here if we didn't get our DTSA compensation, which after all is loss of profits in the normal course. So those are the principles we say ought to be applied when we look at the words of Section 5. And yesterday we spent some time focusing on how it might be read to expunge the compensatory aspect, and we had various candidates for how that might be written. Of course, what I would respectfully remind you is our primary case is that if you take up the words of Section 5(3), our primary case is you don't need to read too much into it if you focus on the word judgment and the language arrived at. Now, if I could just ask you in your Calver Authorities bundle to bring up page 690. It's a Foreign Judgments Reciprocal Enforcement Act.
Yes.
And you'll see the definition of judgment there. It means a judgment or order given or made by the court in any civil proceeding, or a judgment or order given or made by a court in any criminal proceeding for the payment of a sum of money in respect to the compensation or damages to an injured party. And we say there's no reason that that definition ought not to be applied when construing 5(3). And if I can ask you to take up 5(3), it's at 725 of that same bundle. My Lord, I know you're on the electronic copies. If you're able to split screen, if you could bring up the Calver Core bundle at page 70, that would be helpful.
Yeah.
So our primary case is that when you look at subsection 3, a judgment means, as we see there, can be a judgment or order for a sum of money. And then if that sum of money is arrived at by doubling or trebling, if you look as the judge at first instance has set out in paragraph 3, the only thing that would be caught by that construction would be little 3, because that is an amount arrived at by being doubled.
Yeah.
And it wouldn't catch anything else, because when we refer to judgment, it is just an order, as appears there. And you know, the word judgment is used very loosely by lawyers. Judges will often say, in my judgment, I reject the evidence of so-and-so, or in my judgment, this view of the law is wrong. We then look at a judgment which is 70 or 80, 90 pages. Here we say the word judgment is really referring to the relief. Because we're not enforcing the reasoning or anything like that. We're enforcing the actual line-by-line relief. And therefore, when you look at arrived at, that gives it real colour, and it would only catch 3. Now, we now need to look carefully at the constituent parts of the judgment that we're seeking to enforce. And you'll recall that we may just bring it up. Service temp was relied on by the judge in relation to this question of severance, and he said, I don't see any. The judge in service temp said, I don't see any way I can sever this out. And we say that's an error. If you could bring up service temp again, it's 422. and it's paragraph 36 and 38. C, he referred to the broad intention of the legislation to discourage. And in 38, finally, I'm not persuaded that there is any basis for severing the compensatory element from the excess. But, my lords, he did that without doing what the Court of Appeal, in particular Lord Justice Potter, had done in Lewis, which is considering the doctrine of obligation, what the purpose of the Act really was, not considering Rawlin and Fletcher, that says where you can sever, you must, and ignoring paragraph 52, where, as I've said, Lord Justice Potter said, if you are faced as a court with an argument that a judgment's unenforceable, readily identify the bits that are unenforceable and enforce those that aren't, and don't take the view that the multiplication element infects the rest of the judgment. And we see that in the Calver judgment, if we could pick it up. First at paragraph 68, which is in the core bundle at page 83. You'll see there is strong judicial and academic support. Well, we'd respectfully say there's not. It's still somewhat of an open issue. It's never been considered by this court, this particular issue.
Sorry, 68.
Paragraph 68, page 83.
I can't see strong judicial and academic.
Oh, that's 67. Sorry, my lord. Paragraph above. But there so that's that. And in 68, he relies upon service temp. And he quotes paragraph 38. I am not persuaded that there's any basis for severing the compensatory element of a judgment from its excess. And we say that's, given what we've shown you in Lewis and Elides, that's wrong. But that then, if you go over to page 87, see paragraph 91 and 94 under the headings costs and then attorney's fees. That's the approach taken. And in 94 there's reliance on service temp. And so if we could go back please to page 70 of the judgment, 70 of the bundle, paragraph 3. And if you accept that what you're looking at when you're looking at judgment is the relief, cause of action, which is what was relied upon in SAS and also adopted by the judge, just doesn't come into it. It's the actual relief of the orders. There is nothing about the word the judge used, the first instance, was affiliated. There was an affiliation between the costs and the attorney fees with both claims, the DTSA and the copyright, and said in that basis that they're caught by the Act. And the reason we say that is wrong is because even if you apply 5.3 in the more extreme terms that I'm suggesting, they're still not caught, because if you look at 5 and 6 there, they are not a judgment. That is, little 5 is not a judgment for an amount arrived at by doubling or trebling, a sum assessed as compensation. It's none of those things. It doesn't tick any of the boxes.
No, but what about 5.1?
5.1, and in particular, my lord,
Well, 5.1 provides, give me the page number, 690.
725.
5.1 says a judgment shall not be registered, and no court in the United Kingdom shall entertain proceedings of common law for the recovery of any sum payable under such a judgment. And the judgment is a judgment to which this section applies.
Yes.
And that is a judgment for multiple damages within the meaning of subsection 3. So the question is, if you have judgment for multiple damages within the meaning of subsection 3, does that judgment include the ancillary parts of the order?
No, my lord, I say
And
it
that's
certainly.
the question.
Yes, that is, I agree that's the question. I
Right.
say the answer is it absolutely doesn't. And the reason is because 5.1 is the prohibition or the exception, as Lord Justice Potter described it. In other words, at common law, we had a position as follows. We're now creating an exception to the doctrine of obligation and comity. And to see what that is, the extent of it, we go to 5.3. And then 5.3 tells us what it is. And that's why I say the words judgment and an amount arrived at are so important.
So you say judgment means a judgment within the 33 Act means judgment for a sum of money. So why is the interest, attorney's fees and costs not a judgment for a sum of money within that definition?
Yes, and my lord, and I say this with the benefit of several things. The policy here, we say, quite understandably, is we don't want those Sherman Act claims for treble damages being enforced in this jurisdiction against English companies. So that's understandable. But that is said on the imprint of, and we were talking about how the House of Commons addressed it, but they said this is not something extraordinary or new. It's really stating the law other than the exception.
I mean, the problem I have,
yes,
Mr. Strange, is that Mrs. Justice Cockerell, in paragraph 244, if I'm right,
yes, that's right.
said that judgment was to be interpreted as meaning cause of action.
Yes.
And if it means cause of action, then it's not absolutely clear, but it is relatively clear that it includes the ancillary parts of the order. Because if you bring a cause of action for anything and you get a judgment, the judgment will also include the ancillary parts sprung off the cause of action.
Yes.
But you could interpret judgment as meaning the whole judgment, namely the whole order. But in this case, of course, there are multiple orders. It's very hard to see which is the single order. But at the moment, I mean, you accept that it's severable. I think everybody accepted when judgment was entered for the copyright damages that it was severable, this so-called judgment. And you could enter judgment by consent for the 130 million, or whatever it was, for copyright damages. But the question whether that is interpreting the word judgment as meaning an order or a cause of action, and what it does mean in this legislation, because I think it does affect your primary case on the Calver appeal, which is the interest, costs and attorney fees.
Quite. My lord, if I could put it this way, I think it naturally follows if I'm wrong and it means cause of action, I accept then that things associated with that cause of action may be caught. But I say it's wrong to say it's referring to cause of action. And the reason I say that is threefold. First of all, there's nothing in the words to suggest it's cause of action. It talks about judgments. And as we see from the definition of that, it means judgments and orders. Second of all, because of the impact that would have, in other words, taking out otherwise enforceable compensatory damages, I say that you would expect to see clear language. And my learned colleagues will remind me, but in our skeleton argument, we flagged up two other spots. I think it might be 5.2a and b, but there are other sections of this Act where they do pick out causes of action and use express words to say if it's this type of cause of action, it's caught, whereas you don't see that in 5.3. So I say it's just wrong to impute the words cause of action into this analysis. You stick to the normal meaning and logical meaning of judgment. And if you were going to spread it wider than that, you would want very express words to that effect.
Can I see how far this argument goes? suppose you had a case in which it was clear that all the attorney's fees had been spent on the punitive element of a multiple damages claim. Suppose, for example, that the breach had been admitted and the only issue in the case was whether it was willful and malicious so as to engage those, assuming those to be the jurisdictional gateway.
Yes, okay.
So you could say that the award of $20 million, whatever it may be, of attorney's fees was in relation to fees which were all spent on the punitive element.
Yes.
Do you still say that section 5.3 isn't engaged and section 5.1 doesn't apply because the attorney's fees were not themselves a multiple damages judgment?
I know I'm not allowed to ask questions about hypotheticals. I'm supposed to answer the hypothetical, but would there be any punitive damages awarded
Yes.
as well?
Yes, you succeed. The claimant succeeds in showing willful and malicious, gets his multiple damages award, and gets the attorney's fees, which, as a matter of fact, were all, let's assume, or doesn't matter, an identifiable proportion of them, were spent on proving an entitlement to multiple damages, as opposed to the basic claim.
Yes, so there'd be an award of costs all about willful and malicious, X in compensation with damages, and then some trebling. I would say those costs would still be recoverable under 5.1 because they're not. That wouldn't be a judgment that's arrived at by any doubling or trebling.
Well, I understand that that's the logic of your argument, but how on earth does that give effect to the purpose of the Act? You can't enforce the punitive element, but you can, you say, enforce the costs of proving your punitive element.
Yes, and I say that fits so, my lord, for this reason, that the doctrine of obligation, the idea of comity is we're not having your punitive damages here, but legal costs, particularly legal costs, which are assessed on the basis of, because the other thing is, my lord, with that hypothetical, it introduces an element that's not present in our case.
I notice, but I'm testing your argument, and your
Yes.
argument is, as I think you've accepted, that in that case,
Some still enforceable.
you would be able to recover here the costs which are exclusively referable to proving the punitive element of a multiple damages claim which would not be enforceable in itself.
Yeah,
And
yeah.
why on earth should the English courts give you your costs of doing something, of achieving something which it's not prepared to recognise as enforceable?
Because the statute that this jurisdiction passed used the words judgment arrived at by multiplying, and that's not a judgment that was arrived at by multiplying.
But it didn't. It used the term judgment for multiple damages, and that is then subject to 1, which says no United Kingdom court shall entertain proceedings at common law for recovery of any sum payable under that judgment for multiple damages. And surely the interest is a sum payable under the judgment for multiple damages, whether you call it a cause of action, or whether you call it an order, or whether you call it anything. Judgment.
Well, my lord, and I don't want to overuse or over rely or over magnify the words in 3, but I say this: you can't read 1 alone. You have to read 3. Once you get into 3, you are into the territory of a judgment for an amount arrived at. And so, on that hypothetical, yes, I do say that the cost would be enforceable. I think you asked me the question, why should they? And I respectfully say, why shouldn't they? We've got a doctrine of obligation. There is comity. It's legal fees at the end of the day, and it's legal fees that are awarded as they have been in this case, not because there's 5 issues and you prevailed on 3 and they were the punitive, so we give it. It's simply you get your legal fees in a civil claim in the United States if you can prove or satisfy a test. So to go back to the use of the word infected, they would not be infected by the multiple amount.
And do you say the same about interest?
No, interest, I do draw a line between interest.
Well, how do you get that out of the statute?
Because the interest piece would be a judgment for an amount arrived at by dribbling. So if you're against me on the DTSA compensation damages and you say no, that's court, then any interest that's awarded on that is part of a calculation that's arrived at by a doubling or trebling. Because there is a mathematical connection. Whereas you don't have that with costs and fees. The difference is, if I could put it this way, fees and costs are simply decided by whole circumstances of proceedings and willful and malicious, on the one hand. Costs, as in the disbursements, are simply decided by reference to are they properly recoverable or did you charge too much? Whereas the interest, I accept you're calculating on a number and then you're coming up with another number. And the number that you've used to calculate on would be caught by, because it's a judgment which is arrived at by doubling or trebling.
So can I just understand if we're looking at the items
Yes.
set out, in our case, the prejudgment interest, if I understood correctly, actually was all on the copyright claim. So actually...
No, my lord, it's on both, yes. It's on both.
Oh, it's on the compensatory element only.
Yeah, exactly.
It's on the compensatory element only of the...
Yes, exactly. Yeah.
DTSA claim.
Yeah.
Okay.
Yeah. So-
And you say you get that insofar as it's on the DTSA claim because it's on the compensatory element.
Yes.
And then in relation to the attorney's fees, you say you get those anyway, irrespective of whether they can be attributed to the compensatory or the punitive element, because you get attorney's fees on even if they're all spent on the punitive element.
Yes, yes. And then going back to your question, why should they be enforceable? I say respectfully, why shouldn't they be? They're legal costs. It's hard to imagine the objection to attorney's fees being recovered in a multi-cause of action, multi-claim case where they're not attributable at all to the issues. They're just a test has been satisfied, so you get them. I mean, my lord, in one way, I don't want to play around too much with the hypothetical, but you could see a party in a case, because costs don't follow the event in the United States, saying, I'm going to argue that your conduct was willful and malicious, so I can try and get legal fees, and that reason only. So I say we shouldn't go into so much of an inquiry. If you look at 5 and 6, is that an amount arrived at by doubling, trebling, or otherwise? Some compensation? The answer is just no.
So as I understand your argument, 4 does depend on your substantive argument.
Yes, it does.
About the effect of Section 5.
Yes.
But 5 and 6 don't. You say you get those anyway, even if Hytera are right about what Section 5
Exactly. Exactly. So, my lords, and so to summarise that, I say there's the two areas. There's the one, the adoption of the cause of action construction approach from SAS, and 2, the other error is the saying that there's an affiliation is not satisfactory, and it's wrong to rely on service temp, because service temp didn't consider the factors that were considered by the Court of Appeal in Lewis. And that is doctrine of obligation, comity, and basically the 4 principles that I've set out. Now, my lord, subject to any further questions, and I was going to move straight on to revocation. We did come up with some...
So can I just be clear?
Sorry,
what you've been submitting to us about the effect of what judgment means and so on.
Yes.
Going back to the debate we had yesterday about what manipulation you need to make
yes,
to the wording or not.
Yes, yes. So as hopefully it's clear now, I say you don't need to manipulate at all. If you're against me on that, we came up with the following 3 suggestions, and I reiterate, this isn't redrafting, it's just how you might read it, like Lord Justice Jacob. The first was, and I'm just reading the crucial part of 5.3, a judgment for an amount arrived at, insert, and represented by...
Sorry, you have to go more slowly. A
Sorry,
judgment for an amount...
arrived at, and then insert, and represented by, doubling, etc.
Yeah.
The second is, could be read, a judgment, and then this is the insertion, to the extent to which the overall sum includes an amount, etc. And then finally, and this was our, we say the least attractive, but we'll give it to you anyway, is a judgment for an amount, insert to the extent, which is the language from Lord Justice Jacob, and then leave it. And then at the end, less the multiplicand.
Perhaps you could let us have those on a piece of paper afterwards.
Very
Don't
happy
mind now,
to.
but
Yes, we will.
that would be helpful.
Yes, I won't hand this up. So I'm going to
When I say a
move.
piece of paper, I mean for my Lord Electronic.
Yes.
You do.
What I have learned is better to be one or the other, not hybrid like I am, because you're then always struggling. So if I could turn to revocation, the good news here is
you
this.
haven't dealt with amendment.
Well, my lord, I was going to deal with that in reply. My simple point is this. If I haven't persuaded you on these arguments, because part of a permission application would be persuading on the substance, it won't arise. It's in the same proceedings, and it would be in the normal course if you had a preliminary issue decided, and that made a change in circumstances for either of the parties based on the legal findings, you would be able to amend. The only other colour I'll put on it is that we always reserved our position on the DTSA, and this was simply a practical requirement. We haven't bored you with the ins and outs of this case that's been before these courts a dozen times, but there's a very bitter fight going on over collection, and so we took the path of least resistance, which is the copyright claim. Between that and the hearing before Mr Justice Calver, the copyright claim in terms of amounts was rather torpedoed, and so we were left with having to find other choices, and so that's why there was a change in circumstances that required us to do it. So I say if you're with us on everything else, it should not be an impediment, but I'll address it in further.
Well, it's your application. Obviously,
It is.
obviously, if you're wrong about the Section 5 point, there's no point.
No,
amending it.
exactly.
But if you're right about the Section 5 point, the trial is completed at the moment.
Well, my lord, it's the preliminary issues because it was separated out and just dealt with as a preliminary issue because there was the issue of finality was up in the air as well.
It was, but other than that, this was the trial.
Yes,
And
my lord,
subject to that,
Yeah.
it's the whole of the claim
Yes.
that's being dealt with, and
Yes.
the finality point is a relatively small bit left over.
Yes. No, that's
You have to say essentially that you should be entitled to introduce a claim worth hundreds of millions of dollars, which was not advanced at the trial,
Yes.
and that's pretty unusual.
It is pretty unusual.
And
yes, I accept that, my lord.
what is the good reason for not advancing it at trial?
Well, my lord, the good reason is the background that I've described.
It turns out your copyright claim's not worth as much as you'd hoped.
Exactly. And my lord, just two other things. What looms large in a permission application is prejudice, and of course, we argued this fully, and it's not as though the other side weren't able to address the points and argue them. The only prejudice they say is we might have to pay more because we're wrong on a point of law. Yes, that's true, but I say that's not a prejudice.
Well, one of the things that's taken into account, considering amendments, is the use of court resources and other court users.
True.
And that's one of the main reasons why amendments may be refused even where there's no prejudice,
Yes.
when you haven't advanced a claim when you should have done. Do you want to say anything about that?
Well, my lord, and I confess that it's good luck rather than good management, but in many ways we haven't taken up any extra court resource because these issues have to be argued the DTSA components had to be the central piece of both the preliminary issues at first instance and here now. In other words, we had to go through what we've had to go through, regardless of whether we get that amendment at the end or not.
There will have to be a further hearing.
A further hearing,
If you're right about section 5.3 and you're allowed to advance this claim,
yes.
then instead of the present position, which is that we can deal with everything now, subject to the finality point, there'd have to be a further hearing for you to pursue that claim.
Yes, but if we're going down to the practical question of use of court time, we're going to have to go back for finality anyway. So this will be a part of it. And dare I say, there's a few rather large assumptions in there, but if we're right on 5.3 and that hasn't been subject to any appeal, the amount of court time required may be very small. Or it'll be a small element of the finality hearing on the balance of the US judgment.
Okay, so you're going to go to revocation.
Revocation, yes. The pleasing news on revocation is that it does not involve any exhaustive statutory interpretation. We say, in terms of the issues for the appeal, there's really this: did the judge get the law right on 317? And separate to that, was the exercise of the discretion in determining that the enforcement judgment should be revoked correctly exercised? And really there's four simple questions. What are the principles that we ought to apply to revocation under 317? Second question, were they satisfied here? And if not, we say we succeed on the appeal. If we're wrong on that, then there's the discretion question. Was it correctly exercised? And on that, there's really only one balancing act, and that is the alternatives that Hytera had when they agreed to the summary judgment. What could they have done then other than accept a final order against them? Weighed up against what has been described by the Supreme Court as the dead weight of finality. And we say where you are dealing with final orders, you don't start that balancing exercise even. You start it very much in favour of finality, so it takes something very significant to shift it. So our position is very clear. We say where you have a final order, there is an extremely narrow corridor through which a party may apply under 317.
So I've written down you had four simple questions. I'm not sure I'd identified what the fourth was.
Oh, the fourth was the discretion correctly exercised, yes or no?
I've got that as one, what principles do you apply?
My Lord, do you know what
were
I've
they
done?
satisfied? Three, if you're wrong about that, then it's whether the discretion was properly exercised.
Yes. My Lord, do you know what I've
I
done?
think what you said was the third point was that you succeed if the principles were not correctly applied here. And the fourth is, how should the discretion be exercised again?
Yes, and my note exactly for 3 is, if no, to satisfaction, case is complete, my Lord. So 3 is not an issue, it's a conclusion.
Yeah.
Conclusion leading to the fourth issue. Now, our position can very briefly be stated as follows. It's a very narrow corridor to set aside a final order. The factors that the authorities have adopted is a material change in circumstance, or fraud, or some very obvious mistake. And we say neither of those are satisfied. Really, it's only material change in circumstance. But here we say, as the authorities dictate, it has to be a material change in circumstance that wasn't foreseen. And this absolutely was. Hytera reserved the position in their defence on this very appeal. They knew it was coming, they knew what it related to, they knew the arguments, but just reserved their position. So it's not a material change in circumstance, something that was predictable and predicted happened. then, if we do get to discretion, we say the judge was wrong to outweigh finality, the principle of finality, in favour of at least...
It's my fault. So you say 3.17 can only be exercised if either there's fraud or mistake,
Yes.
or there's a material change of circumstances which is not foreseen. Those are the only two circumstances
Yes,
in
my
which
lord.
it can be invoked.
Yes, my lord.
Right?
I mean, I actually said in Unicredit that we shouldn't circumscribe the boundaries of 3.17. But, I mean, there's a prior question here, really, which is whether 3.17 is the right tool to be using here. And, I mean, for my own part, it seems a very inappropriate tool because it is all about case management. But there is no other. And that was why, reluctantly, in Unicredit, we used it. And that's presumably why the other side will say we should use it again here. But speaking for myself, there would be, it's remarkable that there has never been a dedicated tool to deal with the situation where a judgment is revoked abroad, when everybody has known since Dicey began that you can enforce final judgments that are under appeal. So it must have happened before, and I would be interested to know if there's any authority that says how previous courts have dealt with it. But I'm assuming you're telling me there's no such case.
It's been touched upon lightly as to the alternatives. We say, my lord, too, when we're looking at alternatives, you've got to look at it in two temporal moments. One, when the summary judgment is entered into, what could the party have done there other than accepting the summary judgment? And then there's the position that you've just posited, what happens when you've got your final judgment here, but then there's no set aside on appeal. My lord, in answer to your overall question, I think that's why we're here. This is, it's one of those things, often when I come to court, whether it's positive or negative, I struggle to see the actual fair narrative of one party's position, but this one's very delicately balanced. If I was to turn up to 100 English lawyers and say you've got a final sealed order for an amount of money, can that be set aside because something you predicted happened? They'd all say, of course not. Conversely, if you said to that same 100 lawyers, there's a piece of paper that says I must pay X under a foreign judgment, well, that's been set aside now. Surely I don't have to pay. They'd say, of course not. The trick we've got here is what do we do about that situation? And I say, really, it comes down to two things. How high do we put finality? And I say the Supreme Court has said extremely high. And when you are considering, if you want to outweigh that, what were the options available to them? We said they could have sought a stay at the time of the summary judgment. A bit like Nelson J. in Lewis under CPR 24, there could have been undertakings procured. So there Nelson said you can have your judgment, but you are to undertake that you will go to the US court and seek an adjustment in relation to the RICO claim. There could have easily been an undertaking sought that on appeal, if
Sorry,
the
can I
amount...
just take this a bit more slowly.
Oh, sorry, my lord.
So the options that you say should have been adopted
Yes.
at the summary judgment stage was first of all, they should have agreed that judgment should be entered, but provided that there should be a stay indefinitely, or what?
A stay pending the copyright appeal.
And how would that be consistent with the principles that
Well,
you don't prevent enforcement
that
simply because there's an appeal?
Yes, my lord. That is a principle, but as we'll see from the Moss v. Martin case, parties do turn up and say, I want to stay in any event. And one of the issues that's assessed is the merits of the appeal. In other words, is it a strong appeal? And if so, is there likely to be a change in circumstance?
I mean,
So-
I think we're getting a bit ahead of ourselves here. You consented, they consented, judgment being entered, summary judgment being entered for 134 million. And the judgment, as I understand it, was completely swept away in that there is now judgment for something different, namely an assessment, which has got to take place. So there is no money judgment in the US for copyright damages. Now, the first question is, do you say that you are entitled to enforce the judgment for $134 million after it has been here, after the US judgment has been removed?
Yes.
You are entitled, you say, to enforce that judgment.
Yes.
And then all the mechanisms that you put forward as ways they could have done this and they could have done that, are not aimed at achieving the justice of not allowing you to enforce a judgment that has been swept away. Is that that's what you say?
Yes, my lord. When the judge was exercising the discretion, we say he didn't have, but when he was exercising that discretion, it was really a way up between here I'm faced with a final award and all final judgment and all that goes with that. I'm being told, and Vodafone's the authority I'll come to in a moment, by Motorola, that that's effectively bad luck for Hytera, because they had these options available to them and they didn't take them, and therefore they can't now come back. So when I give...
But Vodafone is a different kind of case, wasn't it? I mean, we're talking about a simple money judgment.
Yes.
Nothing to do with punishing people for making bad litigation decisions.
No.
We're talking about a simple money judgment entered in recognition of the fact that a money judgment is enforceable in England. It's entered by consent. And then, as you say, with their eyes open, they knew it might be revoked on appeal, and it was, because they were intending to appeal it, and they did successfully. Now, it's remarkable to me to hear that you say hard cheese is the answer to the problem. You say, well, bad luck, Hytera. It's just tough. Finality is everything. But I thought you were saying there are ways in which, short of invoking 3.17,
Yes.
justice can be done.
Yes, I do say
I'm
that.
wrong
too.
about that, am I?
No, you're not wrong, my lord. I take it in two stages. One, I say I attack the decision under 3.17, but both then and now, I say there are alternatives other than 3.17.
So what application did they make? Just an application under 3.17?
Just under 3.17.
They didn't ask for a stay?
No.
They say they did.
They asked for a stay originally.
My lord, may I just know, we did apply for a permanent stay in the alternative.
Well, sorry. We applied for a stay which was until the appeal, which was granted by Mr Justice Jenkins by his order of January 2024, obviously on the premise that if the appeal succeeded, the judgment would then not be enforceable, or there'd be no point in the stay. Once the judgment was revoked on appeal, we then applied to set aside the summary judgment, or in the alternative for a permanent stay of the judgment.
Yeah, that's what Mr. Rubin just said.
Yeah.
Yeah. So you applied in the alternative for stay, you got the revocation, so obviously you didn't need the stay. But the point I'm making to you is your position that you were entitled, ever after the judgment was revoked, to enforce by attaching for example, bank balances in the UK, despite the fact that that would create obvious injustice. I thought you were saying the appropriate mechanism where this happens is not 317, but to grant, say, a stay and to put some money in court to secure a future judgment, which is what sort of happened here.
Yeah.
Which will do rough justice, but we'll reach a stage where the judgment can be by consent revoked at a later stage, when you know how much is in fact due, and you're not out of pocket and they're not out of pocket. That all seems perfectly intelligible to me. I'm not sure it has legal foundation, but at least it's intelligible.
Well, that was
It's also not what you're saying.
Oh, no, my lord. As I said, both that first instance and here, I take it in 2 stages.
Right.
First, I have to address you on the appropriateness of the variation order, because if that was wrongly made, then it ought to be overturned. At first instance, and again here, we say the proper alternative was really to continue the stay of Mr. Justice Jacob that he'd made. He required that there be 25 million paid into court.
Which it has been.
Which it has been. What we were really trying to do at first instance here was exactly as you've described. What we were saying is, we're right on 317, but whether we're right or wrong, the thing to do here is to stay this until the judgment comes down, the revised judgment.
Let's say we move on. So let's say Mr. Justice Jacob's order had just simply been continued.
Yes.
The judgment had stayed in place.
Yes.
But there was a stay. You had paid 25 million to secure Hytera's position into court, and then the new judgment is handed down, say 15 million, plus a bit, say 25 million, and the appeal is unsuccessful. I'm assuming there's been an appeal in America.
Yes, yes.
So there's a final judgment which is no longer under appeal for 25 million in the copyright damages and costs or whatever it is.
Yes.
Then what you say should happen. So when you come back to court, what are you going to do? Are you going to enforce the judgment? Are you entitled to enforce the judgment for 143 million despite all those events? And if not, what should the court do and why?
Yeah. So, my lord, I say in that circumstances, as we said at first instance, do not set aside the judgment.
Ever.
At this stage, don't set it aside. Stay until we get the remanded decision back.
My lord's point is, at that stage, when you know that the final position in the United States is that the amount due on the copyright claim is only, let us assume, 25 million.
Yeah.
At that stage, what do you do with the English judgment for 134 million?
Oh, at that stage.
That's my lord's question.
Well, at that stage,
that has to be set aside, doesn't it?
Well,
replaced.
Or varied.
Well, can it be varied?
That's
I think it's said against you. It can't be, because a claim to enforce a foreign judgment is a claim on a particular money sum ordered by that foreign judgment.
Well, my lord, the solution, if there's not agreement, the solution is simply we file a claim form with a fresh claim for the fresh amount.
Quite. And you then set aside the 134 million judgment and replace it with a judgment for 25 million.
Yes, or permanently stay.
But what is the power under which... I'm so sorry. What is the power at that stage under which you can set aside the 134 million judgment?
Well, then we're in unicredit territory, although it's not an anti-arbitration injunction, but it's a very different situation where two parties are turning up together to say this is what we want.
But I mean, I'm sure you understand the legal niceties of this. If
Yes.
there is a power at that stage to set aside the judgment and replace it with a 25 million judgment in respect of the final order of the court, which replaces it, why, rhetorically, is there not such a power now?
Yes.
Now, you may say, and I mean, it's a nice point, although it seems utterly pointless, if you know what I mean. You might say, well, the power can only be exercised when we know what the judgment is going to be, because not sure why. But I'm first of all dealing with jurisdiction. And if there is the power to set aside this judgment later in the circumstances described under 317, then presumably there is the power before. And it's really a matter of almost procedure, technical question at the discretion, which probably doesn't take anybody anywhere.
And the circumstances would be no less unforeseen at that stage
Yes.
than they are unforeseen at the stage we're at the moment.
Yes. I've made the mistake of having the argument before. I've shown you the authorities. May I show the
I
authorities?
mean, you can, of course, show us the
Yeah.
authorities, but speaking only for myself, I'm extremely familiar with them. And what they
Yes.
say is that this is a very, very, should be rarely used and only in very exceptional circumstances.
Yes.
None of them is talking about setting aside a final judgment in these circumstances. And
Yes.
I would be very interested to see any authority that considered that. You said there was one. That
Yes, and,
considered I'm not stopping you going.
No. Well, the reality is, you may have seen Newman and Freeman in the authorities bundle. That,
Yes.
That addressed.
Should we look at that?
Well, I don't want to steal Mr. Barlow's thunder. He's dealing with that. That's and in particular, audit Hytera and where that's ended up.
Sorry, I don't know. This is.
If you take it up, it's page 6 of the.
Oh, this is the other authorities.
Yes.
Nubion and Freeman.
Yes, and if you look at page 21, and all I'm going to do is show you this because he will address you on it. And if you'd like him to address you on it now, I'm very happy for that.
Okay, just shows the point.
So it's, if a judgment in a foreign court were reversed upon error and an action upon the judgment had been brought in in an English court, and judgment given in an action on the judgment, and afterwards when the original judgment was reversed upon error, I suppose there would in such a case as there may be some remedy for the defendant who's got rid of the first judgment against him. The remedy of audit Quilera is now abolished, but there is a rule which says that the court may give relief. Now, he's going to address you on that and where that manifests now in the...
I mean, I don't think I'm really familiar with Auditor Quilera, and I would need a little submission on it. So maybe Mr.
Yes, well, I'm very happy to let Mr. Barlow address you on that because I'll be able to fit it in with what I have to say about finality.
Okay.
And my lord, just before I sit down and he stands up, we've got to obviously address the law here and the legal standards. But can I just give you the practical issue that was really going on before the judge and that still exists today? We, in this very bitter, long-standing litigation, have $20 million sitting in this court.
20 million, I thought it was 25.
It was reduced by 5 by Mr. O'Sullivan as part of the consequential. So it's now $20 million sitting here. Our focus is not so much on judgments and whether they're varied, set aside, or replaced by another judgment for another amount. It's making sure that money doesn't go. And the only reason we've got it is because we've got a judgment. So in terms of solutions, we are absolutely...
Well, the only reason you got it is because you got a judgment for 134 million
Right.
that it's been decided you shouldn't have had.
Right. Well, it's been decided we shouldn't have had there, and they're about to give us a different... Oh, and I should update you now. Judge Packode has had extensive submission and argument from the parties. She heard submissions on the remand issues mid-October, so a couple of weeks ago. You may recall from Mr. O'Sullivan's judgment that there was a criminal indictment and there was a guilty plea. That criminal trial has finished and the judge in that trial is giving his decision on the 15th of December. So those two things are outstanding.
Sorry, Judge Packode is hearing what?
Oh, sorry, my lord. She's hearing the remand on the copyright damages. And I don't know if you've had an opportunity to look at the Seventh Circuit judgment, but the key issue there on the copyright damages is one of territoriality.
Yeah, but she is hearing it. When is she going to give her judgment?
Well, very imminently, and the
Well, I think it was said to be imminent last February.
it was, my
So,
lord. The oral argument has now taken place.
But what I'm concerned about is this: do you say, or is it said against you, that if this appeal is successful and the copyright judgment, the summary judgment is set aside, that the 20 million should be released back to Hytera?
That's what they say.
They do say that.
They do say
Oh,
that.
absolutely. That's
They do say that. But
Yeah.
the 20 million isn't a minimum that you're bound to recover. As I understand it, the remand is that it can't be any more than 14 million plus
yes.
interest. But
Yeah, that's
they,
right.
they contend it should be nothing.
Well, no, I think now where we've got to, and I'll be corrected if this is not common ground, but they're saying it should be between 1.4 and 1.7 million, and we're saying it should be 14 odd, and then there's costs and interest. But
You say this is the main point in the appeal, really, if you don't succeed on your substantive point.
not the main legal point, but certainly the main practical point.
The main practical.
Yeah. So put it this way: if we'd been told when the judgment was remanded, let's stay everything in England, we'll leave the money here, find out what the judge does, and then there'll either be a fresh claim or a consent order. We would have been absolutely fine with that. We are hanging on to the judgment, we say rightly, given the jurisprudence on 3.17, but in particular to keep that security.
I mean, I think the way it's put against you is the entirety of your case depends, in practical terms, on claiming an entitlement to keep security, which has been granted for a completely different purpose from that with which the setting aside is concerned.
No, my lord, I would say, with respect, I would say it was put in place for exactly that purpose. So the fight before Mr Justice Jacob in January 2024 was we wanted to enforce the judgment. Hytera said, no, that will destroy us as a commercial entity if we have to pay this amount of money. With the appeal pending, Mr Justice Jacob said, I will give you a stay, but you must pay the 25.
But pending
The appeal.
pending the resolution of the question as to whether the judgment should be
Yes.
set aside as a whole. That's what the security was for, to hold the ring in case you were successful, which you weren't, in your revocation argument.
Oh no, my lord, that
Isn't it?
took place. No, because
I misunderstood that.
No. So my lord, the Jacob judgment was given at a time before the Seventh Circuit had ruled. So it was prior to their ruling. Their ruling came after the security had been provided. There's a chronology, if that's helpful, on this. But no, so if you pick the chronology up,
And that makes it
6-6.
That makes it worse for you.
Yep.
well,
Because if it was provided before the Seventh Circuit ruled, it was really to secure what was looked like being the outcome instead.
well, and that's exactly the point, my lord. The outcome then was them saying, we think the 134 million is rubbish. We think it'll be 0, and at most it will be 14. I mean, the 14 number was before Mr. Justice Jacob.
No, I understand.
Yeah.
So the argument really, I mean, I begin to see what this case is all about. It's obviously not about any of the things I thought it was about. The argument is about whether or not $20 million should stay in court until whenever Judge Packard decides to deliver herself of a judgment. Is it? Really?
Yes.
Is that really all of it?
Well, I don't like to
I mean,
dumb
it's
things.
case management. This is a case management appeal.
Well, it is. That may have been where you were before, but at the moment, you're saying, as I think you said, my lord, you should be entitled now to enforce a judgment for 134 million.
Yes, but I say that technically because,
Well, you say technically.
well, technically in this sense, my lord, because there's a final sealed judgment of this court. Now, technically that's what I say. Practically, what am I after is two different things.
Yes, I mean,
and I can't-
you won't be surprised to hear that, sort of being the master of the rolls, sort of I take the argument that you should be entitled to enforce a judgment for 134 million to which you are patently not entitled, with a pinch of salt.
Yes, understand.
But I understand why forensically you say it.
Yes.
We'll have to deal with the argument because you've said it.
Yeah.
But and I'm just coming back to the practical reality again, because I do care about practical realities. I mean, one could see the common sense if one was sitting back in the commercial court and there were not all these people here and there was not all this marvellous legal paraphernalia. One could see me saying to Mr. Rubin, surely you don't mind pending Judge Packard giving her decision, leaving the 20 million, and then we can have another argument about what should happen when we see what she says. And Mr. Rubin is studiously looking at his tea leaves in the hope that I won't ask him that question now.
But my lord, why not?
But that is what I would say if I were the commercial judge. Now, are the parties really saying to us that they want these sort of panoply of final legal decisions on really important and difficult questions just in order to resolve that? And if you win, the only thing you win is an extra few days of 20 million in court.
Yes, my lord, you've summarised it very fairly, and that's why I'm here. The good news is, I wish I was the carriage for this good news, is that at Nouveau and Freeman, what I've just shown you, and that doctrine has been advanced and is now in the White Book, and forms part of the stay suggestion that we had. Mr. Bala has studiously researched this.
Okay, well, why doesn't Mr.
So why don't I
Bala tell
let
us
him
all
address
about
you on
that?
it?
So just before he does,
Yes.
sorry to...
No, my lord.
Can we just go back to where we first intervened,
Yes.
which is it's just bad luck for them because there are things they ought to have done rather than consent unconditionally, as
Yes,
you put
yes,
it,
my
to the
lord.
judgment, and you were just running through the things that they should
Oh,
have done.
yes. Well, let
And
me
the
finish.
first one was that they should have they should have agreed to enter judgment but sought a stay.
Yes.
Would you have agreed to that?
Yes. Yes. I mean, we're the pragmatic ones here. I don't enjoy standing up before this illustrious court saying, technically I'm allowed to enforce a judgment for $134 million, but I'm rather bound to do that because they are saying we want.
No,
this.
then.
Then.
The stage before there was any successful appeal, and at the time that you had a judgment for 134 million,
Yep.
and you were seeking summary judgment, and they agreed to it, you say they shouldn't have agreed to it. They should have agreed to it only by asking at the same time for a stay. And my question to you was: would you then
Yes.
have agreed to a stay?
Yes. On terms, which we offered, which was payment into court. We asked for the entire amount. They said 0, and Mr. Justice Jacobs said 25.
You asked for the whole amount,
Yes.
and they said 0.
They said
Mr.
0.
Justice Jacobs
Said 25.
No, but
And
not at the time that Mr. Justice Cockrell entered judgment.
well, they applied for the stay almost the same day that the judgment was entered, so it was their stay application. Yeah. And my lord, I'll pull up. I think it's in the bundles, the letter where we wrote saying we will stay. That's my lord. That was execution, obviously. Enforcement and execution. On terms.
Yeah.
Accounted.
So that's you offered to agree to that,
Yes.
subject to
Yeah.
payment into court of the full amount of the judgment.
Yes.
And so I think your second alternative was that they should have sought undertakings that you would go to the US court, and I wasn't quite clear.
Oh no, an undertaking that we would either not enforce or not take more than the top line of the appeals of the 14 million.
So this is at the summary judgment stage,
At the summary judgment,
where there hasn't yet been a determination of any appeal.
No, my lord, you're right that there was
that
no
right?
determination, but it was almost mathematical. If you don't get the extraterritorial damages under copyright, it's not 134, it's 14, together with some other points.
Yes,
So
if you had if that question hadn't been decided then.
hadn't been decided.
Then they
That
should have sought an undertaking from you at that stage. That what?
we would not enforce the judgment above the amount that they say, was the maximum we could win on appeal. And a second undertaking, if we recovered any more than the amount on appeal, we would repay that back.
So the maximum they were contending you would recover following an appeal was
14.
zero. No, zero. They were saying, sorry, maximum. Maximum.
Yeah,
Okay.
yeah, exactly. And there was no middle ground, my lord, between 14 and 134. I mean, it was one or the other.
And they should have consented to a judgment for 134 million, but on an undertaking.
The pending appeal, we would only enforce up to the 14, and anything we recovered above what was ultimately provided, we would pay back.
So, and you would have agreed to that on the basis that an appeal was bound to succeed?
No, my lord, just in
if an appeal wasn't bound to succeed, why on earth would you have agreed to that?
Because, my lord, I don't think anyone has the confidence that no appeal will succeed. No. Second of all, we're pragmatic, but also this is...
It's not a question of pragmatism then. If the appeal hasn't yet been heard, and you were going to contend in the appeal, as I think you did...
Yes, we did.
...that you should be able to maintain the full 134 million, why on earth would you have given an undertaking not to enforce for more than 14 million?
Well, I can answer that very simply, my lord, and that is because my client's chasing many millions unsuccessfully. So if they got $14 million in the door in 2024, on the basis they might have to give a little bit back in 2025, or they may be able to recover the lot. I mean, if you're this is just a pure money commercial question. Take some money now, might have to pay a bit back, might not, and we might get more later. It's certainly better than just waiting for the outcome of the appeal with nothing in your pocket.
That's got nothing to do with undertakings not to enforce. That's got to do with whether you've got money in court as security.
Sure, but
you're saying that they should have said we will only consent to summary judgment
on condition
on condition that you give an undertaking that you won't enforce the judgment, which at the moment is for 134 million, for more than 14 million plus interest. And you are saying to this court, you would have given that undertaking, or you would have offered that undertaking.
Yes, my lord, because the case now is all about the collection of money. And if there was an opportunity to collect a significant amount of money then, and a chance to collect the rest later, that is better than collecting nothing.
Why would collecting have been any better by virtue of that undertaking?
Because we would have actually had the money, whereas
the undertaking is just in relation to what you're going to try and enforce. Not by reference to anything that's given by way of security. Did you in fact offer that undertaking at the time?
No, we didn't, my lord. No.
All right. So that's the second of the alternatives.
Which I detect.
You say what they should have done. Now, I just want to make clear what your arguments are.
I detect
on the it's bad luck part of your case.
Yeah.
Should have sought a stay.
Yes.
Should have on condition of payment of the whole lot into court. Should have. Sought the undertakings. Is there anything else?
Had liberty to apply inserted into the summary judgment order. Liberty to apply following the appeal judgment. And the authorities, both Tibbles and AIC, are clear that that's an option. And then the final one, and I know Mr. Barler's been at the start line for some time now. The final one is Nuvian and Freeman, and Audit Quiera. And he's going to address you on that, but that's my fourth.
No, but I'm sure he is going to address us on that. But can you just tell me what it is they were supposed to have done?
That, my lord, is a...
I mean, that, as I understand it, that's a procedure that no longer exists. What is it that they should have done as your fourth option?
That is a stay now. A stay of the enforced judgment now, given the remand of the copyright damages to the...
So that's something that's an alternative now to
exactly
3.17, not what they should have done then. So
yes.
It's three things they should have done, three alternatives they had then.
Yes.
Which gives rise to it's their bad luck they didn't do them.
Yes.
Now. And then other than that, we're going forward to your arguments on what we do.
And my lord, I will come to it very briefly after Mr. Barler, but in Vodafone, a number of alternatives like this were discussed.
Yes. In the patent context, I've seen that.
Yeah, yes, and we say yes, we accept that they're in the patent context, so they're different, but some of them equally apply here.
Now, I just wanted to have your submission
before
you sat down as to
fine, my lord.
I think there are three things there are three alternatives, and any one of them would would,
Yes.
would have prevented them being in this bad luck position.
Yes, my lord. And I've got the reference, but I'll show that to you later, to what we did say at the time. So with that, finally, Mr. Barlow.
My lords, for the purposes of my submissions, I hope you've received the documents that we sent earlier this morning. It's a pack of 4 separate attachments. We'll give them to the other side in hard copy now as well.
Yes, thank you.
I'll come to those in a moment, my lords. I wanted to start by just introducing the topic, and I shouldn't spend more than 10-15 minutes on this, if that, given the timing concerns. But in essence, my submission will be that there was an alternative, dedicated tool, to use Lord Justice Voss's words, that was open to the judge. And there was, I think Lord Justice Voss described the option of a stay as an intelligible option, but one for which there's perhaps no legal foundation. But what I hope to demonstrate is that there was an alternative procedural tool, there was an alternative legal foundation to order a stay that was far more appropriate than CPR 3.17, even acknowledging that the circumstances in which 3.17 may be exercised are not circumscribed, as my Lord said. And we fully accept that. But nevertheless, there is all the authority with which this court is extremely familiar, including Vodafone, on the restrictions that ought to apply to 3.17 in the context of final orders. And I say, I make 2 overall points. First of all, it's inconsistent with the authorities on 3.17, and that's a point Mr. Sprange has made later. But second, and more pertinently for present purposes, that it's inconsistent with the way, in fact, the procedural rules have developed since Auditor Corella. Now, we could start with Auditor Corella in the 1350s.
So what's inconsistent with the way procedural rules?
Well, what I'm about to demonstrate to you, my Lord, is that one doesn't end up from Auditor Corella, if you trace it through the procedural rules, and these are the attachments I'll take you through now, one doesn't end up at 3.17. In fact, one ends up at a totally different provision, which expressly states that the procedural powers in 3.1 shouldn't apply in these sorts of situations.
Okay.
The starting point, my Lords, is Core Bundle 85 in this appeal, which is the way the judge treated this point, paragraph 84. And I'll just read it out, my Lords. I'm comforted in that regard by the fact that in Nuvian and Freeman, Lord Bramwell did not suggest that an appeal would be the route by which the problem which he had identified would be solved. Instead, Lord Bramwell referred to a type of writ previously used to put right injustices, a power which was expressed in wide terms, but which had been very carefully circumscribed by authority. There does seem to me to be an analogy there with 3.17. And that was, the judge there, Mr. O'Sullivan KC, was accepting Hytera's submissions that 3.17 was an appropriate analogy with Auditor Corella.
I understand the point you're making, but are you criticising the conclusion that an appeal would not be inappropriate?
No, it's the second sentence.
As I understood your submission,
yes.
What you say would be more appropriate than 3.17 is a stay, not an appeal.
Yes, correct. Correct. It's the second part of that paragraph that we're concerned about. Nuvian and Freeman, I don't intend to take the court to it because Mr. Sprange did. But just to reiterate what Lord Bramwell said, and I'd go to the facts of Nuvian if that would assist, I'm not sure it would. But what Lord Bramwell says is, if a judgment in a foreign court were reversed upon error, I suppose there would, in such a case as that, be some remedy for the defendant who had got rid of the first judgment against him. The remedy of Auditor Corella is now abolished, but there is a rule which says that the court may give relief. Now, Lord Bramwell was saying that in 1889, and if I could take the court, first of all, to the first attachment, the first enclosure, which is Jowett's Legal Dictionary, just to set the scene.
Well, for once in my life, I think Jowett's Legal Dictionary will be incredibly helpful.
That's encouraging to hear, Michael.
Understand these funny words, yes. Audita querela, what does it mean, literally?
It is the complaint having been heard, literally in Latin. And as Jowett explains halfway down the page, in old common law practice, a writ given in order to afford a remedy to the defendant in an action where matter of defence had arisen since the judgment, on which the defendant applied to the court, whence the name audita querela defendentis, defendant's complaint having been heard. And importantly, for present purposes, the proceeding by audita querela is abolished, the successor practice being to apply for a stay of execution or other relief against the judgment. Now, where does one find that replacement in the procedural rules? The answer is in the second attachment that we've provided, which is the 1883 version of the rules of the Supreme Court.
Marvellous. I've got the 65, you want the 1883?
1883.
Yes.
I think that's the third one. That's the third one. The second one is 65.
It may be the order's been slightly reversed. It ought to be.
Anyway,
Does my lord have the 1883 version in?
Yes.
Yes. And halfway down the page again.
It's 27, is it?
And the subtitle for the section, audita querela not to be used, but stay of execution when just.
If we look at the body of it, it says any party against whom a judgment is given may apply to the court or the judge for a stay of execution or other relief against such judgment.
Quite. Query what or other relief means.
Yeah.
And I'll show my lord what that particular piece of it becomes later on.
Right.
But a fairly...
Sorry.
Yes.
Just don't take this too quickly.
Yes, ma'am.
You've only given us part of Order 42, as it then was, and it's headed Change of Parties by Death, see Order 17, and the side note is audita querela not to be used but stay of execution when just. Right. Now, what I don't get at the moment is which part of the rules this is, which I would like to know, because if your point is that the train, as I understand it to be, the train from Lord Bramwell through to the present day is through audita querela, for which the alternative is stay of execution or something else under this part of the rules, then the argument is presumably that is not 317, but you need to show us why this part of the rules is different from the precursors to what became 317.
But my lord, yes. On change of parties by death, that appears to be a footnote to the section above rather than the title of what's on the page. But we can certainly provide the court with the full version of the section. What I'm able to submit to your lordships is that this section deals generally with the enforcement of judgments. This is the general section on enforcement of judgments in the procedural rules as they then were. And one can see that from the generality of the subtitles on the right. But if it would assist, we can provide the entire chapter.
It does assist, because you can't understand things taken at random out of the rules. We are no longer familiar with the 1883 rules. Obviously we should be, but we're not. Okay.
Yes, very well. We will provide that to the court as soon as possible.
No doubt my predecessor, Sir George Jessel, was chairman of the Civil Procedure Rules Committee at that time.
My lord, then...
Sorry, it's my fault.
Yes.
what was the relief which was given when Addita Querela did exist? Was it setting aside the judgment?
Well, so this we've addressed in our skeleton argument. In the
Well, what's the answer?
the answer appears to be a stay,
What?
a stay of enforcement.
That's what happened
That's what happened anyway.
on Addita
On Addita Querela.
Permanent stay.
Well, can I show my lord the section of our skeleton argument?
Yes, do please.
Yeah.
'Cause
Which para?
It's right at the end, it's the closing section. Paragraph 44, and in particular 44.3. Nubian and Freeman itself refers to a stay, applying the analogy of order to Querela. The two other cases, the two other authorities we've cited here, similarly. But ultimately, my lords, I mean, it's difficult to pin it down as to exactly what relief was granted. The origins of the doctrine appear to have been an extremely flexible, equitable doctrine to do right as between the parties, depending on what had happened post-judgment. And there's all sorts, I mean, the doctrine itself goes back to the 1350s. I'm not suggesting that we go back as far as that. But it's an extremely flexible, equitable doctrine that is later honed down to provide a specific...
But how do you know it goes back to... Where are you getting this history which you're dangling in front of us? I, speaking for myself, happen to be rather interested in legal history, and I would be quite interested. So if you gave me something to look at, I would look at it.
My lord, well, we have more we can give you on the doctrine.
Order to Querela.
What is currently before the court is Jowett's dictionary, which is a sort of basic summary, but we thought one that would be appropriate. for
Okay,
present
well,
purposes.
you carry on. I want to see
Yeah.
how your argument develops.
My lord, yes. But to finish off the answer to my Lord Justice Popplewell's point, it certainly appears that the remedy was a stay on order to Querela, or at least an option was a stay under order to Querela. But in any event, it's replaced, as we've seen here.
I mean, if it goes back to 1350, that is a period with which I'm slightly familiar because I'm interested in the history of the Office of Master of the Rolls. And obviously the Master of the Rolls was completely irrelevant in 1350 to this kind of activity. But the writs that were issued by the Chancery in 1350 had a specific purpose, and going back to Jowett, the Latin would seem to indicate that it was the specific purpose was to deal with a case where the defendant's complaint, in this case about a judgment, had been heard, but I mean I can't imagine that was in 1350.
But it may well be, I'm guessing, but it may well be that a stay was the form that it usually took, or possibly invariably took, because they were courts of equity who were preventing the execution of a judgment given by the common law courts, where the courts of equity had no jurisdiction to set aside. And it all came from the distinction between the courts of law and the courts of equity,
Well,
which doesn't therefore help us very much once there's fusion.
well, except that 1350 is a very odd time for that to have arisen.
Yes,
So
if it does go that far back, then it may
maybe
that may not be the
may not
explanation.
be
But
it.
certainly
And
by the time
so
one gets to what
So, but-
Brown is looking at in terms of the recent history.
Shall we see where it leads?
Anyway, sorry.
My lord,
Shall we see where it leads in modern times?
Yes, my lord.
With liberty to apply to go back to ancient.
Yes. May I just say as an aside, and I say this without the relevant historical authorities being in the bundle, but my Lord Justice Popplewell is absolutely right. One of the original uses does appear to have been the interaction between the courts of common law and the courts of equity, and in effect trying to reverse judgments of the courts of common law that the courts of equity didn't like. Another use appears to have been where evidence later appeared post-judgment, suggesting that there'd been forgery involved in the case. That's just an an aside as to the sorts
But
of
I mean, this is not an aside. This
Yes.
relationship between courts and
Yes.
of equity and common law changed dramatically between the centuries, and you can't generalize. And if you try to generalize, you're going to go wrong. So let's look at the modern understanding, the post-Bramwell, and see where that leads us, because it may mean that there is no need to go back.
My lord, yes, yes. In fact, it's the law dictionary which points us in the right direction, but we submit that.
Section 41.
Well, the next version we have is next sort of stop for the train is this 1965 rules of the Supreme Court, which ought to be the
That's a very long
third.
stop.
It's a fairly lengthy journey to 1965. Now, Jowett's Law Dictionary points us then to Order 47, Rule 1.
Well, hang on, are we going to look at the 65 rules?
Yes, that's what we're looking at, my lord.
Okay, got them.
So we've just included the front page first. Now, what then appears to be the modern equivalent on the second page, also Order 45, Rule 11. And I should just pause here to point out that Jowett's Law Dictionary suggests that the successor in this version of the rules of the Supreme Court is Order 47, which is over the page.
Well, I mean, that Order 45, Rule 11, would at first sight be relevant.
My lord, it appeared to us to be the almost direct analogue to what we'd seen in the 1880s.
And it disappeared in the CPR.
It reappears in the CPR, my lord. I'm going to show you that next. But to us...
What's 47? 47 what?
47 is... 47.1, it's a similar provision, but it relates specifically to writs of fieri facias. So it's applying this general principle, this general concept that one can return after judgment.
Well, that's completely different.
Yes,
with a
well,
writ of
quite. That's what we thought, my lord.
Yeah, okay.
So our sense is that it's where we should look next is Order 45.11.
Well, because Order 45.11 is looking at the judgment, whereas the Order 47 is looking at a specific means of execution.
That's correct, my lord.
Yeah. Okay.
Now, Order 47, just to make that point clear, Order 47...
So Order 47 doesn't completely replicate
No.
Addita Querela, even assuming that Addita Querela was limited to stays of execution, because it's only the limited area of execution by FIFAC.
Quite right, my lord. Which is why we say that actually, if one's looking for the analogue at this stage, it's 45.11 rather than 47.1.
Yes.
Order 47.1 ends up becoming CPR 83.7, by the way, which itself directly relates to writs of control, etc. I'm not suggesting we look at that, but that's just another reason why 47.1 probably isn't the right provision for us.
With that CPR,
Yeah.
it
So
becomes
that's
which?
yeah. So 47.1, my lord,
Yeah, becomes CPR.
becomes CPR 83.71, which directly relates to writs of control. Of course, that's not something we're concerned with in this appeal at all.
Have you got that here? No.
No, my lord, because we rely on a different CPR provision that I'll show you now. That's the last attachment in the last enclosure is the modern equivalent of everything I've just shown you in our submission, and that's Rule 40.8a of the CPR, which has been in the CPR since the CPR was introduced. It's changed places over the years.
That's why it's got a funny number.
That's why it's got a funny. It was inserted into Rule 40.8 in 2015, and it's been there ever since. And in our submission, it's been made rather less detailed than it was in the past. But in our submission, it's a clear analogue, or at the very least a far better analogue to the scenario which these parties found themselves in than CPR 3.17. And in the history that I've tried to take my lords through, there doesn't appear to be any suggestion anywhere in all of those provisions that the court's inherent procedural powers, whatever they may have been at the time, were the correct way of dealing with things. And my lords, all of that chimes with the authorities on 3.17. If there is an appropriate alternative tool, the court ought to use it because of the importance of finality.
Well, I mean, yes and no, one might say. Yes, you ought to use it at some stage, but what do you do in the end? And my question to Mr. Strange was, what is the proper course at the end? And I mean, I think he accepted that the proper course at the end was to revoke the judgment in favour of a lesser judgment based on the new order.
Well, he may have said replace it or amend it.
Yes.
But take a case in which you have a completely successful appeal, and there is nothing to replace it with. I think your argument is there is still at that stage no power under 3.17 to revoke the judgment. It has to stay in place, but the remedy is to have a permanent stay of execution.
Yes.
Is that right?
Yes.
Now, if that's right, how is that fair? Because having a judgment against you, which ought not to be there and is for all purposes unenforceable, can be prejudicial to people's credit ratings, to whether foreign courts understand it, that it should be treated as if it were completely unenforceable, and so on. So if you're going to grant, if what essentially you're going to do is say this is a judgment which you should never be able to enforce, why is a permanent stay satisfactory rather than getting rid of it? That's, I think, the question I have.
Well, my lord, I mean, there are many variations of what could happen. One could imagine a scenario in which a separate ruling is made, making clear the basis on which the permanent stay has been ordered, in order to mitigate that prejudice.
Well, it may do, but that's still, if someone's thinking of then lending me some money, they look up on my credit rating and there's a judgment for 134 million against me.
Yes, my lord is positing the scenario in which the appeal totally succeeds, so that there is nothing.
Yeah, but I think we have to test it, don't we, by that possibility, because you say even in that case, 3.17 not appropriate.
Well, I mean, there will be harder cases and easier cases, my lord. I mean, I quite accept that if the appeal fully goes away, and one is left with nothing but a permanent stay, then arguably there is some prejudice to the other side. The question is whether that prejudice can be mitigated in some way. In circumstances where the appeal is going to result in something, which at least is this side's position, there are arguments about how much that something will be, but that's our position.
But that's not jurisdictional.
No, my lord.
I mean, the concern I have is, you know, we generally deal with the law here rather than case management questions. And the law has to be intelligible. And, you know, my lord's questions are directed at, in the modern era, at saying, in the modern era, there will undoubtedly be circumstances where it is most inconvenient for such a judgment to be irreversible, right? And I think you would accept that. If the boot were on the other foot, Motorola would not want a judgment for 138 million in England hanging around, even if stayed. Probably has to be mentioned in the accounts and all sorts of other things. So we can see that. But if it were the case that 3.17 is not an available tool, then we would have to say that. And what I'm not getting from your submissions at the moment is whether you really go that far. I think what you're saying is it should only be used in extremis, which is a rather different submission, because it accepts there is jurisdiction to use 3.17, and then it becomes a question of discretion as to when is it appropriate to use it, and how strong or weak are the circumstances, which is a case management question broadly. So, you know, the question of jurisdiction, for my part, you've made good your your point that 317 is nothing to do with any of this and audit quereli and so on, and that there was a process which rather got left in the mist of time, which could result in a stay and is now reflected in 40.8a. I mean, that seems perfectly right. I mean, very helpful, if I may say so. But where does that leave us jurisdictionally when a stay doesn't look the appropriate thing to do?
Yes. Well, my lord, I think it leaves us in a situation where one is at an interim stage, as we were in this case, we don't know what the result of the judgment will be. Then at that stage, a stay appears to be a perfectly sensible remedy for a whole host of different reasons, not least because there will be something coming back before the English court about which the English court must do something. Simply revoking a judgment on the with the English court turning a blind eye to the practical reality that a foreign judgment is going to come back. Now it may be a foreign judgment entirely reversing the position. It may not be, my lord.
But why can't we grant other relief under 40.8a, i.e. reversing the judgment?
It may be that is where my lord ends up, depending on what any other relief really means, and that's itself.
Well, other relief means what it says.
Well, yeah, and that may, and Mrs. Sprague makes a good point, that may arise in a unicredit type scenario, where two parties are coming to the court saying, well, we both agree that the court must exercise its jurisdiction under 40.8a.
I'm astonished that 40.8a was never referred to in unicredit, and I'm astonished that it's not been yet referred to here.
This is the first time it's been referenced in these proceedings, my lord.
Its predecessor.
Although we would say, of course, its predecessor was squarely at issue. At the very least, I mean, the concept of order to querela was before the judge. Nuvian and Freeman was before the judge. The judge asked, what do we know about order to querela?
But I mean, to me, it's attractive to look at 40.8a because I think it's unattractive to look at 3.71a.
Quite so, my lord. At least it seems a far better fit for the situation that we're in.
You would say even if you exercise such a jurisdiction, it should have been done under this provision.
That's right. So the judge erred in any event, because
where's that in your notice of appeal? I mean, I know the answer.
Yeah.
It was a rhetorical question.
Well,
yeah. But you say it nonetheless. And you would
said
apply
I mean,
permission to amend.
Yes, my lord. I mean, what I would say is the point was at issue, albeit slightly further back in history, perhaps, than the current modern equivalent.
Well, it does. I mean, this provision does answer my question, which I've been asking myself throughout this case ever since I've figuratively opened the red string, which is there must be a provision in the rules which caters for it, seems to be. Yeah, okay.
My lord, can I just finish by referring you to the second paragraph of the commentary in the White Book in 40.8a?
Yeah.
And I think this again supports our position. It's making clear that the powers in 3.12, including the case management power to stay under 3.12g, may be exercised except for where CPR provisions provide otherwise. And the commentary makes the point that 40.8a is an example of the CPR providing otherwise. So it's making a separate and further distinction between 40.8a and the procedural powers in 3.1. I know we're talking about a different power here, 3.17, but the judge did in his judgment refer to the possibility of a stay under 3.12g in the judgment. He didn't really explore it very much, but he suggested...
No, you say this is jurisdictional. You say
yes,
it provides
quite right.
Otherwise.
Yeah.
There is a power,
yes.
A specific power to
but it's
revoke,
here. Yes, it's here.
To do whatever you want, stay or revoke or do anything else, and that's what you should do. Yeah.
Well,
And
those
have we
are-
looked at? Have you presumably looked at Michael Wilson's case, one of many, and Hoogstraten, one of many? Have you looked at those?
Yes, my lord. I'm not in a position to address you in detail on them.
Thank you. Well, could you provide
okay.
them to us, because I think we'd like to see them.
Of course.
My lord, if it helps, we have ourselves submitted Raja and Hoogstraten to the court and to the other side
Lovely, thank
this
you.
morning.
Good.
Well, Lord, those are my submissions on this case.
Brilliant, thank you, Mr. Bell. Yes.
My lord, what I will do, and I'll aim to get this done swiftly, is to address you on finality.
Can you consider this point?
Yes, my lord.
It is your real point. It is unsatisfactory to use judgments in a vacillatory manner. So it is unsatisfactory to use these powers, even if you're right that it's 40.8a, to grant a judgment one day, revoke it the next day, grant another judgment the day after that, and possibly, if there were two appeals, which there might easily be to the US Supreme Court, reimpose it and revoke it, and so on. That is an unsatisfactory use of a jurisdictional power because of the finality of judgments.
I agree with that. It is.
That's what you say.
Yes, but my lord, the position that both the parties and the court find themselves is we've got a round problem with only square solutions, in the sense that where we start with this and always where it
What did you say? Only square solutions?
Yes. Here we
Nice expression.
where we
The square solution in this case, rather than vacillating, is to grant a stay.
yes
Is to give the judgment to grant a stay.
yes
Is that
yes. Well, my lord, where we start out with all the jurisprudence is when a foreign judgment's brought to this court, and it's sealed at first instance, it's considered final, and as Dicey tells us, that's not a reason to stay enforcement. Makes sense. But as we see, preparing ourselves for the situation that has evolved here, what happens when the appeal court overturns it? There isn't an obvious solution by reference to case management or jurisdiction.
Well, there is.
there is?
Well,
Sounds as though we finally found it.
we found it, but we have found it in yes,
Other relief?
other relief. But my lord, we have. But it would. First of all, this will be the first time it's ever been done, so it is still a new solution.
I'm the worse for that.
The second thing, my lord, is that this case, and both parties will accept this, is complicated by the 25 and then the 20 million.
Well, it's not complicated by that. I mean, that's not under appeal.
No, well, my lord, it's simply this, that you asked me, and perhaps I could ask you just to take up the judgment, Mr.
Calver, Mr. Sullivan.
Mr. Sullivan's judgment, which we find in the call bundle. Sullivan.
I've got it separately. Just tell us the paragraph.
Sorry, Lord, I'm just using my electronic time this time. A little slower. So you asked me the question that he asked me, which is, what's your formal position? And if I could ask you to take up page 70, which is paragraph 25 and paragraph 26. And you recall there were two, yes, kindly read 25 and 26. You recall there were actually two applications before the court. There was three. There was our adjournment application, we wanted to adjourn it. There was their application to revoke, and then there was their application relating to the money. And on that, if you could take up the supplemental bundle. And
Well,
just to
I mean, he says we have to start with the issue of principle and what powers the English court has and what it should do when the foundation for a judgment is undermined by subsequent appeal. And he was not told about 40.8a, which is the power that seems to have been applicable.
Yes.
Right?
No.
By you. By you.
Well, by anybody.
By anybody.
Oh, yes. If we could go to
Now where are we going?
into the supplemental bundle.
Yes. That's
And-
the other side.
Yeah, and go to page 220.
Yeah.
And you'll see there that Hytera's position, it should be 0, and if not 0, a million or two. And our position was as set out in 27.3. That essentially the status quo should be maintained on the conditional sum. Now that, of course, is an order that could be made under 40.8a.
Sorry, so look, Mr. Justice Jacobs' judgment ordering the 25 million to be paid into court is not appealed.
No. It's not appealed.
Right.
But it's given before the outcome of the appeal.
No, I understand.
Appeal are pending but not decided. Argued but not decided.
Yeah. Okay.
But I know this isn't your primary position,
Yes.
but is your ultimate position that if 40.8a is really the jurisdiction that ought to have been being exercised, then what should have happened is that at this stage, whilst the remand is still pending, there should have been a temporary stay of execution with the money in court, remaining in court. Then, to take up my Lord's point, the position when you get to a final position in the United States is that it may well be that 40.8a entitles one to and would, as a matter of procedure, require the setting aside of the 134 million judgment, but that could be done on terms that it was to be replaced by a judgment for whatever the sum was that gave effect to the revised US judgment. And all of that would be something that could be done under 40.8a, which would prevent what you say is the practical injustice in this case of a revocation full stop, which doesn't carry with it maintaining the money in court. Is that really where you'd be happy to end up if all your other arguments failed?
Delighted, my lord. And in many ways, it's I'm sure you've read the ruling that Mr. O'Sullivan gave post the judgment with respect to what should happen to the 20 million. That's effectively the start of that.
And it also has this benefit that in a more extreme case, where the 25 million or the 20 million was shown to be excessive and was hindering the commercial activities of a impecunious defendant, there could be all sorts of applications about when the terms of the stay in this interregnum period. That may or may not be this case. There may be possible for, I'm sure the Jacobs order has liberty to apply. So I'm sure Hytera could come along and say, we've got no money. I mean, it doesn't sound like it's the case, but they could say that. And we must have this money back, and this is all very unfair. But the vacillation with judgments is something that personally I find quite important anyway to consider, because we don't grant judgments, take them back, grant more judgments, and mess around.
Yeah.
They are final and important. I think the gravity of your final judgment point is that
Exactly.
So all this procedural machinations, which we've now got to, I didn't realise this was a case management case, but now I know it is. I was giving a speech this morning about case management, and I would have mentioned it.
We'll have plenty of new material, man.
Yes, plenty of new material. But that's what it really is.
Yes.
But I'm interested in the jurisdictional questions, and we do seem to have made some progress this morning.
Yes, and my lord, on that, the significant advantage of this route is that you immediately avoid all of the jurisprudence about the entry to the jurisdiction, because you're not looking at change of material circumstances, you're not looking at mistake.
And there's no bad luck about it, actually, because you did get a judgment, and you were entitled to get a judgment reflecting it, and it is a final judgment, but it's not going to result in enforcement unjustly because of the powers of the court to make sure that doesn't happen.
Yes.
And if you were going to, for example, if they were going to say, look, this judgment is ruining our business just by its very existence, which could happen, they would have to come and apply on that ground and see where we got to.
Yes, and here we've got the benefit of Mr. Justice Jacobs' decision with respect to that, because he carefully assessed the impact upon Hytera.
And conversely, it would meet what would otherwise be a difficulty in the simple case where foreign judgment was completely overturned, because then you could use 40.8a to grant other relief, which did involve setting aside the English judgment, full stop, not having a stay. But
yes,
that would be on the basis you weren't concerned with permanent stays, and you weren't concerned with temporary stays because something would still might or might not happen in the foreign jurisdiction.
yes, my lord. As I see it, what the practical effect that's sought to be achieved is that the status quo is maintained until we know what to do, and the party's position between now and then is observed. And dare I say it, the position, I speak for myself, but the next time I've got a foreign judgment case, no matter which side I'm on, I will make sure that the order says liberty to apply under 40.8a.
Well, what
You don't need it.
Well, I don't need it, but
what I'm concerned about is that we did Unicredit
yes,
without any reference to 40.8a.
that's at 252 of the bundle.
I mean, I blame myself. You know, I'm supposed to be the guardian of the rules. I mean, it's why I look up the white book. I hate books, and I can't read the white book because it's too small print. But it's actually there in the right place where you'd expect it to be. So it's no excuse for that.
My lords, it's been an eventful morning. Is it helpful if I, in the next, say, 10 minutes, just show you the finality? We'd perhaps even rise early. I would frankly like to take some instructions over the break.
Okay.
And then if I've got anything to say after that, I will, but otherwise I'll hand over to my lord.
Will you take the 10 minutes?
Right, so, and I know these authorities are well known, so I'm going to hit the high points. Could we start, please, with RALT? That is in the authorities bundle, starts on page 76. Decision of the Court of Appeal, leading judgment from Lord Justice Hughes. The sad facts of that case are summarised in the head note. It's a settlement case in a personal injuries action. An agreement reached in relation to future care in a local authority, then a decision subsequently that should be private care, and an attempt to vary the settlement. And we could take up page 82 at G. CPR 3.17 cannot bear the weight with which Mr. Graham's arguments seek to place on it. He then sets out the At H, the two categories, so erroneous information or subsequent event destroying the basis on which the order was made. And then A on the next page, please. It does not, in particular, it does not follow, and I have no doubt, that where the judge's order is a final one disposing of the case, whether in whole or part, and especially it does not apply where the order is founded upon a settlement agreed between the parties after the most detailed and highly skilled advice. The interests of justice and of litigants generally require that final order remain such. Then if we could go finally over the page.
.8 not mentioned here.
No. And then 18 shouldn't have been exercised. And if we look at 20, this is the point about the material facts. What has happened in this case is not that there's been an event which destroys the basis of the order, proving the settlement. The most that has happened is that in one important respect, the prediction of the future has changed so far as the claimant's parents are concerned.
Happens all the time in personal injury cases.
Yes. And then F, it was always foreseeable that the prediction might turn out to be erroneous, that is simply unavoidable. And I say that it's not precisely the same, but it's the same where you've got a judgment and you're appealing it on a neat quantum point. You're only allowed damages for internal, not external losses. It should be 14, not 134. So if we can move on to Tibbles, that starts at A105. Well, that's probably, as you know, the most comprehensive walk through the authorities up to that point. I won't go through them all now, but I will show you on page 115, please. The order in this case was by a slip. Those costs recovered under the fast track when it was in fact a small claim, and that was wrong. And it was an attempt to set that aside. What's very important here on page 115, though, is there's a discussion of Briggs J as was, paragraph 38, Kajomi and HSBC Bank. The facts are set out there, but the important thing there, he says, is on the basis that even limited scope for the rule allowed by the jurisprudence commencing with Pat and J's observations did not apply to final orders. So there, drawing an important distinction between interim orders and final orders. And then if we go to the next page.
40.8 not mentioned.
No.
Sure.
Yes, we Mr. Weller and I have spent some time on this, and it was only through the moving through Niven and Freeman and Aquaterrace, so audit Aquaterrace as to how we.
Well, Mr. Russon, in his case,
Moss and Martin
mentions 40.8.
I will be coming to that shortly. If I can just show you the paragraph 39 on 116. This is Lord Justice Ricks drawing all of the principles together. I could just ask you to read what's at B, 39B.
Yeah.
And then if you could please look at the next page, paragraph A. So this is 117A. This is the discussion of liberty to apply. It was sort of moved on somewhat, but when I gave Lord Justice Popplewell my list, one was to put liberty to apply in the consent order for judgment. Now, there's just two more. If we could please take up Terry, which is at 138. A claim had been brought, default judgment granted, an attempt to set that aside on the basis that the entire claim that had been brought and led to the judgment was fraudulent, and you'll see that summarised at paragraph 17 on page 140. Permission to appeal was granted, and when it was granted, Lady Justice Gloucester, in granting permission to appeal, put 3.17 up as a possibility, and we see that at 22. So that's how it got addressed. And it's summarised, page 156, paragraph 75. So it's very rare, given the importance of finality. And then lastly, on this, if I could please show you AIC, which is at page 173. Now, the focus here was more about a change in circumstances between when an order had been made and sealed. And the predicament that the deputy judge was dealing with was that an order had been made that a party enforcing an arbitral award wouldn't proceed with that on the basis that a guarantee was being provided. That was the order. The guarantee wasn't provided, so enforcement started. Then the guarantee came in before the order was sealed, and so you had a party with a guarantee and enforcing. Went to the Court of Appeal and then to the House of Lords, and just ask you to read the head note, please, at 174, page 174, paragraph B, per curiam. And we say we're at other kinds of final order which in the proceedings at first instance will track the finality principle to almost a great degree. And if you go to 39, except these principles aren't stated in the context of 317, but we say they apply with equal force. The question is whether the factors favouring reopening the order are in combination sufficient to overcome the dead weight of the finality principle on the other side of the scales, together with any other factors pointing towards leading the order in place. And of course we would say where there is an alternative that's now been identified, that's weighted consideration. And then lastly, if you could look at the bottom of page 187, 45, it says here the judge did not give the finality principle the central importance which it deserved. Then there's a discussion, but the passage I'm most interested in you reading is at the bottom of that page, going over to the top of the next page. Importance of guarding against that erosion.
Yeah, she wrongly regarded it as an even balance. It's not an even balance when you've got a fund.
Yes, and we say that's where the judge in this case fell into error, because his conclusion was that that finality was not really relevant. That was at paragraph 74.
Well, he had a point, didn't he? He didn't mean it like you say.
No. But the way it's said there, I say, it is a peculiar case, but it's not relevant because at the end of the day...
Can we look at Moss and Martin?
Yes, my lord. So Moss and Martin. That's at tab 14.
Because Judge Russon seems to be the only one amongst all these distinguished courts that happened on 40.8, but I'm not quite sure what he made of it.
No, having had Mr. Ruston as an opponent over the years, it's not a surprise.
No. But, what's the case?
So, my lord, this case involved a Texas judge. Oh, sorry. Here we go. Yes. So the issue here was related to a stay pending a Texas appeal. And you'll see in paragraph 36, that's where the reference is.
So this was an application for a stay under 40.8.
Well, there was a debate as to whether the...
Identified both.
Uh,
6.
If you go to 51, my lord.
No, 3.12F, which is not the same.
Oh, yes, sorry.
So did you say 39?
So 36 identifies it's an application under both.
Both.
3.12.
37, you'll set out the judge's discussion with counsel.
31.2F, 3.12F, I believe, is an interim case management power to order a stay.
Yes, my lord. And then 37 is the key passage. And then in 38, apply by analogy CPR 5216. My lord, then I'll leave you to read
He
that.
was on
bit.
the money, really. I had initial doubts about that.
If you pick it up in 39. That's how we ended up. You'll see in 40 with 83, CPR 83.71.
Yeah, okay. Yep, that's helpful. It's also 1 o'clock.
My lord, well, I will stop there. I was going to show you the reasons for the rejection of the stay, which we see at 58, but I'll save that for another time if we get there.
Okay, well, you're finished, are you?
I'm finished, my lord. I'll just check with my colleagues in my notes
Yes,
over
okay,
lunch,
you
and
can come back after.
I'll also plan to get some instructions on
Yes, that's fine.
practicalities.
We'll resume at 2 o'clock. Thank you.
Thank you.
Court rise at table.